Folks, welcome today. It is a great pleasure to present to you an overview and summary of the U.S. Citizenship Act. I am going to just give this a few minutes. People are joining us right now. The focus today, of course, is President Biden's U.S. Citizenship Act. The president indicated that he would move fast on immigration in the first 100 days. And we have seen a very bold, comprehensive immigration approach. Joining me today is my partner, Phil Curtis in Boston. It is a pleasure to have you all on board and just getting us up to a critical mass in terms of numbers here. A little bit, just the standard legal disclaimer. Today, what we are giving is not legal advice. If you do have legal questions, feel free to reach out to myself, Bernard Wolfsdorf, or my partner, Phil Curtis in Boston. And I think I'm just watching the numbers. We're up to close to 100. So I think that is going to be fine to get started. So for those of you who are just joining us again today, welcome everyone. My name is Bernie Wolfsdorf. I'm the managing partner of the WR Immigration Law Firm, joined by my partner, Phil Curtis in Boston. Thank you, Phil, for joining us today. Our discussion will focus on President Biden's U.S. Citizenship Act. This is an extremely comprehensive reform bill, but the focus today will be exclusively on what does this mean for business and employment immigration. For those of you who have questions, we would be most grateful if you could please use the chat function at the bottom of your screen. We'll try and answer all of those questions during the course of today's presentation, and but we may have to keep most of them for near the end. If for some reason your question is not answered, please also feel free to reach out to myself. My email address is my name, Bernard at Wolfsdorf, and you can also reach Phil at pcurtis@wolfsdorf.com. So this focus again is primarily on business immigration. And again, this is not formal legal advice. A little bit about our firm. We are a full service immigration firm with 7 offices. We have over 40 attorneys practicing exclusively in the immigration and nationality area. Our specific differentiator is the fact that our firm focuses on innovation and technology, which coupled with high touch and seamless execution provides a critical service. I'm the former national president of the American Immigration Lawyers. One of my partners is the current vice president, numerous awards, chambers, band 1 in California, tier 1 nationwide. Little bit again about myself. That picture's a little bit old, but I think we're allowed to use it right now. A little more gray hair. Practicing immigration over the last 4 years has certainly added to the gray hair. And I am a certified specialist in this arena. And but speaking about my partner, and Phil, thank you so much for going through the hundreds and hundreds of pages of draft legislation to synthesize for us today the few key and critical aspects so that employers can understand what this new proposal is all about and what the prospects of success are. So I'll be the moderator today. Phil is your primary speaker, and you will find him both knowledgeable and clear in his presentation. Phil?
Okay, well, gee, thank you very much, Bernie. And then people actually get a chance to hear from me. A couple of background points. Bernie and I coincidentally each has about 35 years of experience practicing immigration law. We got started at about the same time. And before I was a lawyer at all, I had a career as an air traffic controller. So that maybe helps my clarity. But I'll turn it back to you, Bernie, to get us rolling in the program.
I love that fact. So you're going to steer us clear of the danger zone with your foresight and deep insight. So, you know, again, this is not the subject for today, but if you haven't heard about RAPID, you will be hearing about it. We've been working on this program for the past 3 years. It does have the most robust analytics, amazing reporting function. This is our innovative platform designed specifically for global mobility, which seamlessly integrates with HR using cloud-based technology. People are just raving. They're like, oh my gosh, I didn't know anything like that even exists. So if you're interested and you haven't seen it, come and have a look at RAPID. It'll take you 10 minutes. So today's topic, and on to the nitty gritty. Oh, we have a nice turnout today. We have almost 125 people. So what we're going to focus on, again, directly in the area of business, what's good and not so good in this bill. The good news is there's more good than not good. So we're very positive about this bill. We are going to discuss the path to citizenship and other non-business provisions, but not with the same area of focus, because we are going to respect your time and focus primarily on employer and business aspects. We're also going to look at what is the realistic possibility of this becoming law, this bill. Will it get enacted? And then finally, of course, the possibility of a piecemeal solution, which is that parts of this bill may well be enacted. And we are already seeing, next week, we will see parts of this bill peeled off and introduced in the House as HR 6. So moving forward now, Phil, help us a little bit. What are the four most important aspects that you see in this bill that would help employers and foreign nationals in the employment-based context?
Thanks, Bernie. Well, so it's really bullets 1 and 3 go together. One of the main structural problems, it's been plaguing us for well more than a decade, is the combination of the limitation on employment-based green cards of about 140,000, combined with per country limits. No single country can account for more than 7% of that total. And the third thing is that when we count employment-based immigrants, we count not only the employee, but also his or her family members. So the structural problem is built in because we bring in H-1B workers without the quota for H-1Bs does not take into account dependent family members. So one H-1B worker gets counted against the H-1B cap. We bring 85,000 people in every year, but there's a 2 to 3 to 1 multiplier when you count family members. And when we go to the green card allocation, those family members get counted against the green card. So the result of this has been that over the last couple decades, unconscionable and enormous waiting lists have built up, primarily for people from India and China. And it's created a situation where we attract talent to the United States to do critical jobs and then basically say, well, you're here, but you actually can't become a fully functioning member of society for 10, 15, maybe 20 years as you wait in these ridiculous lines. So that is just a demoralizing and a huge impediment to moving life forward, if you want. And what the main thing that this bill does for employment-based immigration is it basically eliminates those waiting lists. And it does that in a couple of ways. First, it takes all these dependent family members, spouses and children, and it no longer counts them against the cap. So that effectively doubles at least the number of slots we have available for employment-based immigration. The next thing that the bill does is it eliminates the per country limitation. So everybody's sort of competing fairly for not the same limited number of spots, but a greatly enhanced, a greatly increased number of spots because we no longer count dependent family members. And finally, this is not in the PowerPoint, but the bill goes back and it tries to measure visa numbers that we didn't use in years past and bring them into the present. And that by itself would probably free up over 200,000 additional visas. So basically, doesn't sound like all that much, but it's a huge reform in the way we treat people. And it would go along, these provisions that I just mentioned would go a long ways towards making life a lot easier and more predictable for employers and, frankly, equally importantly, the people that work there. Bernie, reflection on that?
Well, I'm the eternal optimist, but at the end of the day, the multiplier in the employment context for most nationalities is approximately 3 to 1. So I think it's going to be a hard battle. We will talk later in this program about what are the prospects for success. But to be direct, I'm not going to hold my breath on this one. I think parts of this make so much sense. People who've been waiting at least 10 years. The removal of the per country debate has been going on vociferously for at least 10 years. And the question is, well, good. Let's hope that the terrible situation that Indian and Chinese nationals, more Indian than Chinese, have suffered will be resolved. But I am a little bit skeptical about whether or not they're going to increase the employment cap by 200-300% at this time. I'm hopeful. The point that you mentioned about recapture of unused wasted visas in the amount of about 250,000, yes, I see that happen, but again, can't be 100% sure. Phil, one point that I do think is really helpful in here is at the moment, only H-4 spouses in backlog with backlogged immigrant petitions can get work permission. The idea that spouses and presumably children on H-4s can also work during their summer, I think is really nice. George Bush did something similar for E2 and L1s, and I think it's time to let, that's George Bush Jr., that it's time to let spouses work as well across the board while waiting for their green cards. Back to you, Phil.
Right. So that's absolutely right, Bernie. We're talking about the other sort of major good things in this bill. Providing H-4 spouses and children the ability to work is huge. And it's interesting that the bill provides this benefit to children, because dependent children, if I'm thinking correctly, are not permitted to work in any other non-immigrant visa category. So this would single out
Correct.
H-4 children for special treatment, which you could be controversial. We'll talk a little bit later about whether any of these things will actually become law, but allowing people who are here in the United States as dependents to work is really, it's almost inhumane not to. And the fact that we're now talking about doing it is really good news. The other thing that you could put in the kind of the humane category, I guess, if you want, is the provision that would says, look, if you waited 10 years, we're just going to take you out of the numerical limitation. You've waited long enough. We're not going to torture you anymore. We're going to let your green card be adjudicated without regard to numerical limitations. That in effect also increases the number of visas that are available. But it's really, as I said before, unconscionable to make people wait for decades to enjoy, to become Americans, really. And this is a I don't think this particular provision has ever been proposed before, and it is it's a really good sign that the administration is thinking along these lines. It's at the very minimum, it's getting the discussion out in front of everybody to say, listen, what we're doing to people, regardless of whether what your political persuasion is, you have to accept that it's just not fair. It's not how we should treat people.
I don't think people fully understand how bad the situation is at the moment. It's been 32 years, Immigration Act of 1990, since these quotas were set. Our economy has grown 5-6 times as much, but we still have the same quota. So we kind of a little bit out of date. It is time to reform immigration law. And I'm certainly hopeful that most of this bill will go through. I'm a little bit skeptical whether all of this bill will go through, but let's keep going. So these are the other good provisions. And I think this bill benefits the best and the brightest. Fill us in. What else is good in this bill?
The first bullet here is, you would think, would be as close to, I hate to use the term no-brainer, as anything in this 500 or 350 pages of legislation. The bill says, look, if you have a PhD in a STEM field, science, technology, engineering, or math, you don't count against any of the caps that are otherwise out there. We're just going to take you out and say, we'll make you go through the normal hoops, labor certification or EB-1 petition, but you're not going to count against any cap. That's how important you are to our economy. And that is absolutely, if there was one thing in this entire bill that I would think could go through, that should be it.
That sounds like the Andy Grove Intel provision where he said we should pin a green card on all our STEM PhDs and not let them leave rather than kick them out. I think in the past few years, we've been kicking out some of our brightest graduates from our top schools. And quite frankly, that just doesn't make sense. So this is another super smart. What else do we have in here, Phil?
So the dual intent provision for F1 international students it looks like a big deal, but in my, basically that's saying to an F1 student that you can hold the intent that we require you to have to leave the United States and go home after you finish your schooling, which is the classic non-immigrant intent, but you can also hold the intent to become a permanent resident at some point in the future. We're not going to count that against you in getting a visa stamp. That's nice. It's a nice recognition of what it's really, to me, is a codification of about 90 to 95% of reality anyway, because American consuls are very lenient about giving F1 visa stamps to people. Some exceptions maybe in certain third world countries. But basically, if you're coming to the United States to study, you can prove that you've got the money to do it. We're going to give you a visa almost all of the time. But it's nice to have this dual intent recognized. Age 4 children extending beyond the age of 21 is, actually, you want to say something about the students, Bernie?
No, I just see we have a very good question here. On the STEM PhDs, does this include H-1Bs or just green cards? Phil, my understanding is it's just for the green cards. There's no cap exemption for H-1Bs. Right. And in fact, when I was ruminating about the bill, I was thinking, is there anything in this bill that would help us in regard to the H-1B cap season, which is always nerve-wracking? We're right in the middle of it, starts today. Basically your statistics are sort of 1 in 3. Does this help us in terms of H-1B selection at all? I think the answer is no, but back to you, Phil.
No, it does not. That's one of the, I suppose you could say, disappointments in the bill is it doesn't address the H-1B quota or cap at all. I'm sure that was a deliberate omission.
Well, there's the one aspect that, quite frankly, not to be argumentative, which I don't like, but we're going to address later, is that they deal with the salary and the selection process, which we'll get into the weeds a little bit further on. But just to answer the question, Yeah, it doesn't do enough for STEM PhDs in order to be able to stay, but presumably, if there's no waiting lines, they may not even need H-1Bs. And we'll get to strategies later where they could jump straight from STEM OPT to green cards if they've got a 3-year STEM OPT and no green card waiting line. We may not even be doing as many H's. Phil, any comment on that?
No, I would agree with that. And I think that's actually what most people would anticipate is just going straight. If you're a STEM PhD, you skip the H-1B process altogether and just go straight for a green card. Just to sort of quickly wrap up the other sort of provisions of the bill, H-4 children keeping their H-4 status beyond age 21 would be the first time we've ever given a dependent visa status to somebody who was more than age 21. And that I think is designed to help out families who have been sitting in line for decades and watching their children age out and then have to deal with the US immigration on their own, a very good development. And then finally, the last point is I find a little bit odd. The Regional Economic Development Pilot Program sets aside up to 10,000 green cards for people who are deemed sort of critical to the economies of where they live and work. And beyond that, we don't really know because it's going to depend on regulations that have yet to be written. So I would say that one is not going to be a particularly wide applicability. It's in there. It's kind of interesting.
Yeah, I think it's a good concept. There are parts of the United States, as we well know, that are not doing as well as others. And if we can use immigration to help those areas that have been adversely impacted by numerous factors, then yeah, that makes a lot of sense. By the way, we did have another question. I was a little bit sort of conclusory, just talking about H-1B caps. For those of you who are relatively new in this arena, once a year, employers get to apply for H-1Bs. The total allocation is 85,000, of which 20,000 is set aside for people with master's degrees. Bottom line of the H-1B cap situation is that those people who are subject to the cap are generally going to have somewhere between 30 and 50% chance of being selected. It may be a little bit better this year with less applicants, but we've pretty much had about 225 to 250,000 people competing for the 85,000 H-1Bs in the specialty occupation. So another good question.
We've also been throwing around the cap term kind of a little bit loosely because not only do we restrict H-1Bs to 85,000, as Bernie said, but also we restrict green cards for employment-based people to 140,000. So there are really two kind of separate limitations that are going on.
And when we say 140,000, remember that, family with a spouse and 4 kids is taking 6 slots. So that's one of the critical elements that Phil mentioned earlier, that we don't count the derivatives anymore. It's a massive improvement in terms of actual visa application. We have a question here. Do you have the statistics for the master's chance? I generally tell people with a master's degree, you're at probably 45 to 50%. And by the way, that's a US master's degree. We have another interesting question. I may be breaking Phil's flow here by answering it, but since we spoke about dual intent, there's a question, will we have dual intent for TN holders? TN, Treaty NAFTA, although it has a new name now, of course, but we still call it TNs. So that is for Canadians and Mexican. This is the H-1B equivalent. No, those are not dual intent visas. Those individuals do have to show that they have an unrelinquished residence abroad. But as a practical matter, it is my belief that most TNs are able to renew their visas if they are waiting in line for a green card. Phil, I'm Oh, we do have one more question, and I'm just watching my time. We have time for it. I'm not sure if I understand it correctly. So per the new provision, STEM PhDs from India, China can apply for EB2 and don't have to wait for years to get their green card. So this is correct. My understanding is that a STEM PhD from India or China applying for an EB2 NIW will not be subject to the quota, assuming this provision, these are proposed, assuming this provision is in fact enacted. This, folks, whoever's asking this question, yes, you will be very, very happy if this bill, and specifically this provision, is enacted. But as my partner Phil has made clear, some of this stuff is going to go through and some is not. So perhaps it's time to lobby, but back to you, Phil. I guess.
Let me just fill in around this particular question, just one little bit, which is not only can you do EB2 NIW, but you could do a labor certification based EB2 and still not have to wait in any kind of line. So that's a real incentive to finish up your PhD, get your thesis done.
But I am seeing a sophisticated element in this question, which is the bottom line is that if you did an EB2 perm, not an NIW, an EB2 perm, and you require only a master's degree, are you still going to be exempt because you have a STEM PhD? So I find this question quite sophisticated, and I'm inclined to say that I believe the answer is yes. But so people understand how all of this works is, number one, this has to be enacted. Number two, the government has to propose regulations. Number three, they have to implement it. So how it finally turns out we are not able to go into the weeds because, quite frankly, we don't have regulations. We just have the outline. But I think that was an excellent question. And my understanding is that's why I call this the Andy Grove Intel provision, possibly one of the best parts of this bill in terms of welcoming the best and the brightest, is to exempt STEM PhDs, even if they are applying under other categories. But I think we're going to have to wait a little longer before we get a definitive answer on that.
Based on my quick reading, Bernie, I would agree with you.
So, folks, let's now talk. We've had the good. Everything we've discussed is good. I'm not sure if I'm going to call this bad, but I'm going to say I don't like this. And I think my partner Phil was going to agree with me. Phil?
Well, I may like it even less than you do. So the first provision here basically allows whatever administration happens to be in office at the time to declare that it's going to limit green cards, employment-based green cards, because in its opinion, some areas of the country, including possibly the entire United States, are experiencing high levels of unemployment. So what don't I like? I mean, you could say this makes a little bit of sense, because why would we welcome lots of immigrants to the United States if we can't fill our jobs? But the problem with this kind of language, and this is true no matter what context you're in, is that it's undefined. It basically gives the government, the administration, in my opinion, almost unlimited authority to do whatever they want. And you could basically you could simply, by declaring that there's a high level of unemployment without necessarily proving it, and certainly without having to prove a particular high level of unemployment or a particular way you go about showing that, or particular industries that are affected, you could basically shut down employment-based immigration because you happen not to like it. And that is really dangerous. So my personal opinion about legislation is that it ought to have standards, it ought to have predictability, and ought to guide us in how we manage our lives. This does none of those things. It simply says that we'll let this administration or a future administration decide on its own that it can essentially clamp down on employment-based immigration, or limit it to particular geographic areas, which would be equally pernicious.
Well, I agree with you, Phil. And, we saw the last administration take a highly restrictive view towards immigration with a quite effective. Of course, they had COVID, and that is obviously another critical factor. But at the end of the day, the administration was successful in reducing the number of green cards substantially. And I think, it may have been consular closing, but the number of unused visas in the employment and family arena is astounding. I think we're looking at 60-70% reduction over the last few years. And the second point that I have in this regard is, there's another thing COVID did. And the question is, where is this specific area which has got a high unemployment? We now have, at least in our office, pretty much everybody's working remotely. Most of my employees have moved out of state, not most, a lot, have moved out of California and are enjoying Arizona and other lovely places. So where is this high unemployment area? It seems like people can work from pretty much anywhere for many of the jobs in our economy. So I'm concerned that somebody acting in bad faith may use this type of provision to shut down a particular industry or area or adversely impact. And our system has always focused on due process and fairness, hasn't always achieved it, but that is what Phil and certainly I believe is the ideal. So let's move, Phil, to the H-1B priority.
So the other major controversial issue in the bill is prioritizing H-1B visas based on how much money you make, or based on how much money your employer represents that you'll make in the petition or the registration that's filed. So this is we're going to talk in a couple of minutes about what chance the entire bill has of passing and why, or why not. But the idea of prioritizing H-1Bs based on how much money you make is not it's sort of weirdly bipartisan. There are a number of Republicans, the Trump administration, who believe this is the way to go. And there are also fairly liberal Democratic legislators from, I think, maybe primarily, I'm guessing a little bit here, areas of high productivity like Silicon Valley or possibly even Eastern Massachusetts, who think the same way. And the argument goes, look, we should be giving out H-1Bs to the best and the brightest, and the market's going to determine that. So if you're making, let's say, north of $175,000, the market's determined that you are valuable, and we ought to consider that in H-1Bs. So we should give them to the people making the most amount of money. But the result of that would be basically that we would eliminate entry level or lower tier people from, and lower tier, I don't mean, worthwhile, but in terms of how much money you make, from consideration for H-1Bs, which would have a dramatically negative impact on international students. And derivatively, or as correlation, college and universities. If you're an international student coming to the United States, the idea that you can work after you graduate is hugely important. And if we take that away, if we say, look, you can come here and get educated, but the likelihood of you getting a job post-graduation or post-OPT is somewhere between slim and none, then I think that the attraction of American universities is going to go, colleges and universities is going to go way down. So it's this prioritizing wages or H-1Bs based on how much money you make has got really a couple of seriously valid sides to it. And that's a debate that I think needs to get sort of addressed inside the Democratic Party.
I totally agree. And, it's very problematic. By the way, one of the questions, and thank you, by the way, we're getting some very interesting questions, but the question that I thought is very valid. Here it is. Sorry, it just popped up. So the comment is that at the end of the day, wages in some parts of the US, like the East Coast and West Coast, may be substantially higher than that paid in the middle of the US. So that is adding a geographical disadvantage, is that those states that pay, look, it's a reality. A $50,000 salary in Dallas is a whole lot better than a $70,000 salary in New York, and yet they would be disadvantaged in the selection process. So I totally agree with your question. This is bad. And here's what else just to give you some history, is that the Trump administration actually put through a final reg on this. The good news is the Biden administration has postponed it. So we're not going to see this prioritization for the current H-1B lottery that is going on right now. That's the good news. The bad news is that Biden's got the similar provision in his bill. So I think it raises some considerable problems from a geographic point of view as well. We have another question that I just want to, it's not directly on topic, but certainly related, and that is the status of the new prevailing wages that were introduced by the Trump administration. Is this something that the Biden administration will revisit? And the answer is yes, it's being looked at, but we're getting some kind of wacky prevailing wages coming back in the perm and other arena. Phil, any comment on this related issue of, because in a way, the Department of Labor and the Trump administration used the current published prevailing wage guidelines as a tool to effectively implement this exact proposal by just pushing up the wages so high, and then USCIS taking the position that level 1 wages are not adequate for H-1B.
Well,
Phil,
yeah,
any comment on that one?
Sure. I mean, I agree with you that the Biden administration is sort of taking a much more careful look at this. Also, we need to mention that there are several lawsuits out there attacking the prevailing wage regulation as completely outside the scope of the statute. And most of us believe that the regulation would be enjoined. But we'll have to see. So I mean, I would give that reg a less than 50-50 chance of surviving past the 1st of July when it's supposed to go into effect.
So Phil, I'm going to help you move on, but the last question we have here, is there anything in the bill which helps redefine what is a specialty occupation or adds more criteria to qualify? And the answer is
No.
not that I'm aware of, and we will continue to have a pretty tough time qualifying people for H's. It's not going to get any easier, but that's the way it is for the president.
Let me just interrupt you for a second on that point. First of all, I totally agree with the comment above that the wage-based prioritization stifles innovation. Absolutely. But as far as H-1B prospects are concerned, most of you probably know that there have been a slew of lawsuits challenging what we would characterize as, improper denials of H-1Bs. And most of those cases have been successful. And the success rate of H-1Bs suddenly started climbing again. So we may, it's never easy, but we may see a return to some version of normalcy in the next few months on H-1B adjudications. At least
I'm not holding my breath, but I'm expecting a more positive attitude. I think we will see USCIS continue to be quite tough in its adjudications. It's not, we've got Mayorkas as our new DHS secretary. He was a deputy secretary in USCIS. I wouldn't say adjudications were easier when he was running the show, quite frankly, but I think we'll see a better overall attitude. Let's move forward, because just watching your time as well, we'll circle back to questions at the end. So Phil, we've focused again on business employment provisions. That is only a small part of the bill. We could do another hour or two on the other very extensive provisions, family law provisions. This bill is heavily focused towards benefiting family immigration, which was the centerfold of the 1952 Act of family reunification, but that is not our focus today. So, Phil, what else do we have in the bill which would be have a significant impact on immigrants generally?
Well, so yeah, this is an enormously complicated or complex bill, and we haven't even mentioned many aspects of it, like we're trying to fix what's driving northbound immigration from Central and South America, or primarily Central America. But let's talk for a minute about a few of the provisions that are, in my opinion, going to guarantee that the bill does not pass as constituted, as an entirety. And these are all great things. But the first bullet is basically, it collects people who we would characterize as dreamers or DACA recipients. So basically children who enter the United States as minors, not typically of their own volition, they're brought in by their parents, who are, since they've been here, have look like good citizens. What I mean by that is that they have high school diplomas, or they have college degrees, or they've been working for 3 years. There's a provision for a pathway ultimately to citizenship for these folks. Also for people who have been in the United States under temporary protected status or deferred enforced departure. These are people that, if it's TPS, that the Attorney General has determined are from countries that you're unsafe to return to. And DED are people that the Attorney General has decided, even though you might be not here on any lawful basis, that we're not going to kick you out. And collectively, Bernie, what are the numbers here? We got many hundreds of thousands of people.
I wanted to just sort of butt in and to, this is the dreamers, the first group of the dreamers. And as I say, even former President Trump used to say at some point that, we're not going to send the dreamers back home. It just doesn't make any sense. They are very American. They're very integrated, very involved in healthcare, COVID, front lines. I mean, this is the dreamers, and that's what I was referring to. HR 6 being introduced next week, by the way. And then the Promise Act, this TPS, El Salvadorans, Guatemalans, here in LA, I think we've got about 250,000 El Salvadorans, a critical element of our economy. Remember, folks, it's not only the best and the brightest, but it is also, in many respects, the unskilled workers that are in terrible short supply. I mean, you're talking about childcare, agriculture, which you'll get into, the jobs that, quite frankly, many Americans simply don't want to do, or as I like to explain in case I need to defend myself, my children won't do. They won't make their own beds, never mind some hotel bed, but perhaps that's my parenting. So, Phil, what are the numbers? I think it's important to note this is not a general amnesty. This is not providing a path for the 11 million undocumented that are in the US. This is merely carving out two critical categories. Number one, the dreamers, which we think is probably about 1 million, and the TPS and deferred departure folks, which I don't know the numbers on, but I'm speculating is over 500,000. So we're looking at maybe 2 million possibly out of the group, but please don't quote those numbers. Phil, back to you on the other two non-business provisions, which I think are very important.
Certain agriculture workers, basically, there's a pathway to people who have worked in agriculture for 400 work days in the past 5 years, that sort of recognizes how important they are to our economy. I mean, goodness knows, very little is more important than getting food on our table. So those folks are given special treatment in this act. And then finally, the act would repeal the 3 and 10-year bars for people who have overstayed their visas by more than 6 months leading to a 6-year or 3-year bar, or more than a year leading to a 10-year bar, which would be a hugely beneficial thing. Whether it has any chance of success, I think the answer is
Well,
probably no.
well, you know, I always have my little opinions, but there are many people who feel that the 3 and 10-year bars are the reason we have 11 million undocumented. It is fairly well established that many foreign national workers would come over, work for a while, and then go back home. The problem is that if they go back home, they're now banned from coming back for 10 years. So the irony is that, and I'm sorry to say, this is a Clinton provision. During the Clinton administration, the 96 IRA Act was designed to discourage people from overstaying, and yet it's trapped millions of people here. So I'm not sure how effective this 3 and 10-year bar thing is in terms of discouraging people from overstaying their visas, because it effectively traps them, because if they stay, they're not subject to the bar until they actually leave. And as for the agricultural workers, yes, we do need food. But hats off to the agricultural lobby. They are always very effective. And well, we need agricultural workers again. My kids will not milk cows, although I understand that it can pay quite well. So, Phil, let's move on to.
Okay, so why won't this pass as it was drafted? And the answer to that, I think, is fairly simple, and it's the filibuster. That we could probably get a majority. Well, I think that this legislation could probably pass the House as drafted, but there's enough in it that would cause, I think, more than 40 or 45 Republican senators to vote against it. There's a deeply embedded resistance to anything smacking of amnesty. And while Bernie's absolutely right, there's not a general amnesty such as there was back in 1986, but there's a pretty solidly entrenched view by at least a substantial number of Republican senators that anything looking like amnesty is a bad thing. So I think that the non-business provisions that we just talked about are enough to pretty much, in my opinion, I hate to be so discouraging, guarantee that the bill doesn't pass as constituted.
Well, I'm the eternal optimist again. The two major immigration legislations that did go through previously were bipartisan, but they did rely on something that we're not seeing so much anymore, which is the Republican business, the McCains of the world. But I will point out that Marco Rubio, Ted Cruz, Lindsey Graham were part of the what they call Gang of Eight. Was that 2008? We came razor close towards reforming our immigration law. Unfortunately, that was blocked at the last minute by some of the more conservative Republicans. But the truth is, nobody knows. My hope is that our president is quite skilled in terms of negotiating. My hope is that there will be a bipartisan approach towards reforming our immigration laws. Phil sort of touched on this, but a lot of the provisions that are in the bill address problems of Central America, people coming in through our southern border. Everybody understands that we need to have borders that are respected. They use terms like open border coalition. There isn't one. The fact of the matter is that we all understand there have to be limits. There have to be reasonable limits, but there is no doubt that we also need to keep our best and brightest. We also need to ensure that we have adequate, unskilled, trying to find, elderly care, child care, agriculture, unskilled jobs, unfortunately, are still not being filled and impacting our economy to some degree. So, Phil, if this is not enacted, what do you think might be carved out?
Well, so first of all, we have to look at the question of, can anything be carved out? What has prevented prior efforts at immigration reform from saying, okay, we can't get the whole thing, then why don't we just settle on a few things that we think are reasonable to get, i.e. Pro-business stuff, has been a resistance on the part of Democrats to doing that. Democrats have, this was back in the old days when Republicans were generally perceived as pro-business. Democrats felt that if we let the pro-business provisions through, that we would never get the comprehensive immigration reform. We would never do anything for the 11 million undocumented. We would never do anything from the Dreamers or the DACA people or those agricultural workers. So if that's still the attitude, then we're not going to get anything. But Democrats have not had a chance to debate this notion for a long time. And so this is an opportunity for the Democratic Party to decide whether or not it would agree to carving out parts of this act that might be able to make it. So if we're going to have that conversation, I would say that the DREAM Act folks on the sort of humanitarian side, the non-business side, has the best chance of making it out. The DREAM Act kids are just a hugely attractive and sympathetic group. It's pretty hard. You have to be, it's pretty hard to come out and say, look, these people who have been here for, most of their lives and are contributing to society, many of them valedictorians going on to college and stuff like that, should be thrown out to countries where they may not even speak the language anymore. But so there's a, that would be one thing we could carve out. On the business side, it's difficult to say. We talked about STEM PhDs being the one thing out of all the business stuff that could easily come out, and I believe that. But whether Chuck Schumer and others now in power in the Senate, not to mention the House at all, would agree to do that, I think is an entirely open question. We haven't had the opportunity for the Dems to debate that among themselves.
Well, I like to be optimistic. I agree with you, Phil, that I don't think we're going to see all of this bill, but I do think we're going to see some relief. I mean, some of the aspects such as recapture of wasted, unused visas, I think that's something that possibly the R's could accept. My other optimistic assessment is that within a few months, COVID will be on retreat. I believe it is already on retreat, and that we will see a huge boom to our economy that will further put pressure on the need for skilled workers and the best and the brightest. So I think employers are going to be put under pressure within a few months, and by the end of this year, maybe early next year, having this bill in place. By the way, as drafted, this bill would be effective October 1, 2021. So we're talking about this bill optimistically in terms of visa allocation. I mean, there's different dates for different provisions, but in terms of allocation of immigrant visas, the effective time would be October 2021. So I'm going to remain optimistic. I will point out again that the previous legislation, everybody said it didn't have any chance. Let's be hopeful. Let's be positive. And I think we've already pretty much addressed this concept of what do we expect? Do we see the possibility of a Mitt Romney or Lindsey Graham? Quite frankly, Lindsey Graham used to be quite reasonable on immigration. I think he's still supportive of some programs. Let's be hopeful. perhaps not too hopeful, because that also could be described as naive. So, Phil, what are your parting comments on the prospects of this bill?
Well, I think there's an interesting question here at the end here is when do we think that some of these provisions could be made into a law in a year, 2 years? Do we have any idea? And Bernie, I think you had, when we were prepping for this, to comment about this, there could be a little bit of fast tracking going on here.
Well, there absolutely is fast tracking. In fact, HR 6 is going to be introduced into the House. We're talking next week. And that is the Dreamer provision and the Promise Act. Now, the reason why they're being introduced is, generally speaking, of course, before a bill can be voted on, it's got to go to committee. They've got to have hearings on it. But Congress previously held hearings on the DREAM Act and on the Promise Act. So those bills are ready to go, as it were, are ready for prime time. And I think that if those bills go through and are enacted, that will also provide some momentum to fix other aspects of the bill. I do believe, I'm a little bit of, look, Biden is a whole lot more experienced. He understands the Senate, I think, better than any president we've had for a long time. He sat in that body for enough years. He knows the people. I think he's respected. And Phil, what's your view? I mean, there's other Republicans, Sue Collin, Lisa Murkowski. All they need to do is peel a few of those away and address the filibuster question. And I understand that the filibuster question is being looked at again after West Virginia and the stimulus bill went through. We had one Democrat who held out. So we don't know what's going to happen with the filibuster. So I'm remaining optimistic and positive, but I'm not going to hold my breath on many of these provisions. But I did think that it's important for us to spend an hour today to understand what's on the table, what are the prospects of success, what's the good in this bill, which is 80%, what's the, I'm going to call it bad. There are one or two what I think are not good provisions, which I hope are weeded out in the process. Phil, I'm looking at our time. We're down to 2 minutes. I think we've answered all the questions today. I will remind all of you that we can be reached. This is our contact information in Boston. Phil's there on High Street. I used to live in Boston. A little bit cold right now and icy. We've got 2 offices in LA. We've got the Woodland Hills office and the Santa Monica office, which is where I'm based. We have our Bay Area offices in Oakland, Sharina Garcia, and Farshad Algi running the San Francisco. And then my partner, Naveen, is in the New York office. We also have a small Shanghai office. If you're in Shanghai, this is one of the most beautiful buildings, the Kerry Center. Definitely worth a visit. And I hope we will be available to you if you have any questions. This visa law at Wolfsdorf is in fact my direct email address. If you need to get hold of me, if you need to get hold of Phil, it's P. Curtis at the same last name. I encourage you all to subscribe to our newsletter at wolfsdorf.com. We do publish this on a weekly basis. We also have regular seminars, regular webinars, and if you can't remember any of this, 1-800-VISA-LAW, 1-800-VISA-LAW, and you will reach the law offices, our law offices, WR Immigration. Thank you, everyone, for joining us today. I hope that this has been informative. Thank you, Phil, for plowing through hundreds of pages of legislation to give us what I call the juicy tidbits and the vital information that we need to know from an employer's perspective. There will be additional follow-up. So thank you for saying thank you. And we really appreciate the privilege of speaking with you all today.
And
On
thank-
that
yep,
cheery
thank you,
note, Phil,
everybody. Yep, no, thanks everybody for your time. Been a pleasure.
thank you so much. Bye-bye.
Bye-bye.